Hey, everybody. Welcome to an unexpected afternoon rescue mission live stream. But Matt and I actually both have plans tonight, so we could not talk about what happened in court today if we were doing it at our normal evening time. So welcome once again, Matt. Just before we went on air, you were telling me you got an interesting call from a reporter today. What was that about?
I did. I guess our esteemed general counsel, the only actual attorney within Kristina's window, says he is pushing the story that the only reason Kristina is being removed is because she will not illegally use or earmark the funds that they got from the NRCC. And this is based on something that they were told to do, which contravenes what they were told in writing to do. And that's the reason why Kristina is being removed. Thank you, Kelly. There's a long story behind it. Thank you, Patty. You know the long story behind it. But yeah, I mean, it was such a preposterous comment that he was looking for something on the other side. And I said, guys, this started way, way before the NRCC letter.
Yeah. They just get more and more desperate. It's so bizarre. But anyway, so we had day 2 in Grand Rapids. And I'm mad because my laptop has frozen where I was copying my notes down. But first off, DeLisle testifying again. She was testifying for the better part of 3 hours yesterday, or 2.5 hours, something like that. And then another 90 minutes of cross today.
Something like that, yes. You know, this is, and counsel, John Lauterbach, counsel for Melinda Pago and her side, honored the judge's compressed calendar. So the judge said, I have 2 half days available for you. So they had to sort of pick their winners and who were they going to bring in. And they brought in 3. Ann DeLisle, who was the secretary of the January 6th and January 20th meeting, who can testify as to what occurred there. You had Thomas Birch, author of the Roberts Rules, literally wrote the book. And then today you had Maggie Kurzweil, who is a state committee member and also happens to be an attorney.
Yes. And both of them and Maggie, just completely unbreakable is what I gathered. Oh, I got into my laptop. Now we got notes I can look at.
Yeah, Maggie is not someone I don't think anyone who's ever met her would say, I'm going to challenge you sort of to a verbal tete-a-tete. That's not going to end that well.
Yeah, I guess there was one point where the defense lawyer asks her, Are you an attorney on this case? Which is, kind of a snide way of saying you're trying to do your lawyer's work for you. And she's just like, what'd you say? Something like, hey, I get it. And then he says, look, I'm just doing my job. And she's like, I know you're doing a good job. Something like that was what happened.
Well, and like I said, we had, there's an old saying, when you are right on the facts, pound the facts. When you are right on the law, pound the law. When you're right on neither, pound the table. Mm-hmm. And Mr. Collins, I'm sure he is a very good attorney. He is actually, his practice area was attorney discipline. Right, Campbell. Yes, I'm sorry, Campbell. He's a Collins Langhorn. He's a good attorney, but he's not arguing in front of a jury. He's arguing in front of a judge. So the judge is not only what they call the determinant of evidence. Is this evidence admissible? Which there were a couple of matters that they discussed. But he's also a trier of fact. So he gives weight to that evidence. So, and he knows the games and the things you play. One of the defense strategies is start and stop, right? You start down one line of argument, then you switch 5 pages further and change the line of argument, and you're trying to catch the person up. Not with this group of people. I mean, they probably know the facts and the law better than the attorney. So it wasn't a particularly effective strategy, but the judge wants to lay it all out, and the judge wants to have considered everything before he makes a ruling.
Yeah. So speaking of that, I guess that was the big upshot. What people are going to be talking about is that the judge didn't issue a decision from the bench, but he did say it was going to be next Tuesday. There's going to be, and he gave them an opportunity for even more evidence and witnesses. Although to that point, the other big thing was the defense had none. They didn't bring any. They called no witnesses. I was thinking I mentioned this in one of my tweets near the end. I was like, the defense has used up all their time on cross. They must not be having any witnesses to bring in, and they brought in none. Not Kristina, not anybody.
Yeah, my understanding is that they had a couple that were under consideration. One that they're considering bringing their treasurer, and their secretary. This judge, based on his ruling on their motion to dismiss, is willing to hear oral arguments but generally prepares his thoughts and he reads them from the bench. Not every judge does that. Some judges just read it, but this judge is going to read it from the bench and then supplement it with actual opinion later. So he did that on the previous day, on Monday, or whatever it is, Tuesday. Sorry. So the judge indicated he'd be ready to rule on the 4th. I'm sorry, on Tuesday at 4:00. But if you want to bring some other evidence, you can. Which to me, as an attorney, that says I won't say he's made up his mind, because it's a very complicated issue and he's got to dig through all the pieces of it. But I think one side has made the case. She's been removed. They tried the whole line of, judge, you don't have the right to decide. The judge dismissed that. So a lot of the defense's arguments in his closing statement were along that lines. This is a party dispute. Well, judge already reviewed that and threw that out. The judge says, no, this is a bylaws interpretation dispute, and I do those all the time. And I have the right to do that here, and I've been asked to do that here, and someone's got to give him a reason not to.
Yep. So, by the way, Dennis Marberger on X says, greetings, gentlemen. Dennis, hope you enjoyed my video on Monday about Stefan Kinsella. But anyway, yeah, it seems to me that, I mean, this was, as you said, they had nothing to add to anything. It was an hour and a half of them trying to browbeat and DeLisle into saying something and getting nowhere. And then some more time spent doing the same with Maggie Kurzweil and getting even worse. Just getting completely shot down. Yeah,
that's right. And what the interesting one was, they were trying to preview their argument, their line of argument. For example, their line of argument is some of these people hadn't paid their dues, and that's why they couldn't have participated. Okay, all right. And then they asked, did they pay their dues? And the answer is they did. And the worst answer is they did, and somehow some of these payments didn't make their way into campaign finance reports. So instead of relying on their own records, the Melinda Pago's team picked the phone and called. Hey, Sue Aller, District First Chair, great lady. Did you pay your dues? Why, yes, I did. Can you prove it? Why, yes, I can. And here's a payment I made this day, this amount to the MIGOP. And if the Kristina team, which they did, was relying upon their own records, and their own records are shoddy, now I understand why Jennifer Stanifer didn't testify. Because you're going to have to answer the question, if this person paid you, here's the bill, here's your campaign finance filing, it's not there, why not? And if she says, it's because our records aren't accurate, that's the only possible answer. Well, then all your thing as a treasurer, which is, I have good records, should all be thrown away. And that's the trap they're going to get into on that and potentially other testimony.
Yeah, that's, I think the one thing they're going to go for is trying to claim that some people weren't members in good standing and therefore their signatures didn't count. That's the one tack. The other tack is to try to get the TRO, as it was in Kalamazoo, to say there's not immediate harm here and this can just be resolved by the RNC at some later time. And that was where Lauterbach made some points about the fact that, first off, every day that goes by, this is damaging the party. And if we have delegates that go to the wrong place because Kristina is still posing as chair, then that's a problem too.
Right. And keep in mind, though, this is not a TRO. This is a PI. This is a preliminary injunction. We just followed, and the judge mentioned it. There'll be a trial, because after a preliminary injunction comes a permanent injunction. Now, normally, the standard for a PI is basically the same. Preliminary injunction is basically the same as a permanent injunction, maybe with a little bit more factual basis around it. So once you lose the one, you kind of know you're going to lose the other. But you never know. But the judge here, and this is different, most of the time a TRO is, sometimes it's on, there's factual, but maybe it's in the form of affidavits. This was on sworn testimony in front of the judge. And they laid out as many facts as they thought they needed to give the judge every bit of evidence he needs. And what they did was, and over the course of 2 days, this day and the last day, they systematically threw out, ground to a pulp, every counter argument that Kristina's team came up with. Oh, it can't pop. You needed a quorum of 75% if you were going to remove the chair. Not true. Tom Birch. No, that's wrong. You called the special meeting on the 13th was called properly. No, it wasn't. Tom Birch again, and over every single talking point that they've been running around town telling everybody, it's all been systematically destroyed. And I only wish we could put together a nice little summary. Boom, 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 boom. So when someone says, "Hey, I heard that," no, that's item number 6 on this list.
There's the RNC's memo.
Yeah, exactly. The RNC's memo is pretty good about that. It has the most important ones, but this one carved every single counter argument they had, carved it into pieces.
Yep, it's pretty great. And I don't know. I'm sure they're going around saying, "Oh my gosh, he didn't issue the restraining order today or the preliminary injunction, so we're good. We're good. Everything's great. We're going to have our convention in Detroit. Hey, go ahead, have it."
I mean, look. I've cautioned people. The judge is not going to say you can't meet. Okay, so if they all want to go down to Detroit and meet, they're going to have every right to do so. First Amendment freedom of association. You may do so. Well, there's things you're not going to be able to do. You're not going to be able to call yourself the Michigan Republican Party, probably. This is all probably. The judge could do whatever they want. You're probably not going to have access to the checkbook. Okay. You're probably not going to be able to send out emails calling yourself the MIGOP. And this is important. If you do, you're going to be violating a court order. And judges really, really don't like that. So when they drag you into court and say, "Hey, this email went out from the Michigan Republican Party," you're not, if you're Kristina's team, you're not going to be able to say, "I don't know, I didn't send it out." And knowing that it was Joel Studebaker or the Felon Owens or one of these other clown shows, you're not going to be able to do that. The judge is going to have a really, really short fuse for ignoring court orders. So they're going to have to decide at that point, what do they do? How do they proceed?
Yep. Ron Picard says the checkbook is big if all the bills haven't already been paid. Well, that's another problem they're going to have, is because apparently the state committee is now giving Kristina Karamo whatever money they have left in their accounts, which is going to be problematic in the
Very
future.
problematic. They now, the interesting part is they say they've paid for their convention in Detroit. Well, you better have, because if you haven't and the checkbook gets locked, it's not going to work. And the two people need to understand this. The money that the Michigan Republican Party has right now, all of it, is from two sources. One is they asked every candidate to contribute $20,000 towards the convention. Okay. And that was some time ago. I think there were 6 candidates at the time, and they got $120,000. The other money is a check that they got from the NRCC, the National Republican Congressional Committee, of $263,000. That money is supposed to be used for House races. Now, you can have an argument within your state about which House race should they be hitting. Is it John James in the 10th? Is it you go for Tom Barrett in the 7th and try to win because Slotkin is gone? Do you try to defeat Hillary Shelton? Do you backstop Jack Bergman? Where do you go with the money, right? Those are all good questions. But it's unequivocal that that's what the money is supposed to be used for. And they laid it out in the letter that they sent sometime back, where they said, "Hey, just FYI, this is where this money came from. It came from regular people. Regular people donated to protect the House, right? And that big pile of money is piled up, which is allowed. That money is distributed to state parties, which is allowed. And it's designed to protect the House." Now, people can have different positions. I know you've spent a lot of time on bad votes in the House and bad management. You get that. But unquestionably, it's going to be worse with a Democrat, right? You're going to get, we've seen in our own state House.
Well,
so pick your thing, right? Pick, that's where the money's supposed to go.
Yeah. Although the issue is, I think legally they can't force the state party not to steal it. But
correct. They cannot. But my analogy was this. I had an interview with a reporter, and my analogy was this. If dad sends you to the store for a gallon of milk and gives you $20, says, "Come back with a gallon of milk," and you come back with candy. Now, dad can't go to the store and say, "I want my money back," but you can darn well sure you're not going to get another $20 from dad.
Well, that would serve their agenda. Remember, their agenda is to destroy the GOP. So if they're not getting any money from the NRCC anymore, then they've achieved their objective.
Correct.
The issue I think there might be now, though, is that they have illegally voted to pay Kristina this money that they were not entitled to appropriate at this.
There's no question, and that was the counter argument that was raised in the case. Is they said, what about the meeting on January 13th? What about the meeting on February 17th? And John Lauterbach said neither of those are real meetings because those were run by Kristina Karamo and she's been removed, which is unquestionably true.
Yeah. And
in addition to that, this is a series of just horrific either legal advice or legal execution. They banned 6 people from the party for 5 years, from the party itself, right?
Yes.
Not the state committee, from the party for 5 years, which
including the co-chair.
Right, including the co-chair, which, by the way, is a plaintiff. So the plaintiff gets to say, if this isn't the MAC, I'm banned from the party for 5 years. So guess what? That's irreparable harm. But all those meetings were predicated on her having the authority to change committees, to run a meeting, to call a meeting, to set an agenda, to take votes. All untrue.
Yeah. And I think they did actually get to this too, because they also improperly fired Ann DeLisle as district chair with no evidence. This lynch mob, which is what these state committee members supporting Kristina are, in my view, evil people, because they fired somebody who was not there to speak on her in her own defense, had no hearing, and who most of them had, a lot of them probably hadn't even met some of the proxies, and ultimately they've disenfranchised her from the party for 5 years. Is what they chose to do. Yeah. And their grounds was conflict of interest, which there wasn't. And as Ann pointed out to the judge, I've not taken any money from anybody for any of the things I've done.
Well, they didn't ask the follow-on question, which I wish they would have, just for my own personal. What was and this is, again, when they bring someone up, Jennifer Standiford, they bring up Angie Gillespie. Go ahead. Let's ask this question. When you were reviewing the conflict of interest waiver, what did you determine was a conflict of interest? Because we had somebody walk into our committee that you live in and I'm on, saying, well, the conflict of interest was, ready, if you disagree with Kristina Karamo, that's a conflict of interest, and therefore you should be removed. I can tell you what that sounds like to me. That sounds like East Germany. That's not conflict of interest, and doesn't meet any standard of anything. Yeah. So good luck explaining that to the judge.
Yep. So there you go, folks. That's what happened today. Tuesday, we will know what the story is, or what the story shall be. If you have another moment or two, Matt, actually, I just got an interesting legal doc that just came into my email today from the old Kalamazoo case, which we can take a peek at right now, if you'd
love to.
This is a plaintiff's motion in limine to challenge. Let me make this bigger.
Mm-hmm.
To challenge defendants' proofs of possible evidence and witness list. The funny thing is, one of the first cases that got me into these legal shows actually is a case that they called the LOL suit. Like if you go to lolsuit.com, you'll find all these case docs on this case that these people were talking about years ago. And one of the things that was the recurring joke is that the plaintiff's counsel could not get apostrophes right to save their lives. They would be wrong every single time. Every time they spelled plaintiffs with an S apostrophe at the end where it shouldn't go, I always pictured Daffy Duck going, plaintiff! And this is all over this thing. Plaintiffs, singular, motion, despite there being 2 plaintiffs. Motion in brief and limine to challenge defendants' proofs of possible evidence and witness list, even though there's multiple defendants. Plaintiff, by and through undersigned counsel, moves this court for an order to strike or limit defendants' witness list and limiting the defendant's proofs based on defendant not complying or answering. Plaintiff says there's 2 apostrophes in this one.
Oh.
Discovery request.
Oh.
Defense witness list. On or about June 19, 2023, defendants submitted a witness list in response to the court's order to submit one for the evidentiary hearing scheduled for July 3rd. See Exhibit 1 defense witness list, which is a dang long list. It's got a lot of witnesses to call in this case here.
Yeah.
So there you go. That's their witness list. And oh wait, hold on, let me scroll up further. Get back to this motion here. At the time of the defense submission of this list, defense counsel was only on a limited appearance as to the KGOP and had submitted a summary disposition motion as a response call to all of the defendants in this cause. The evidentiary hearing scheduled was not incorporated into count 4 of the amended complaint, and those witnesses listed in the defense witness list were neither listed to testify as to defamation or as witnesses for trial, being defense counsel had yet to file a notice of appearance as to his representation for KGOP and under information and belief for Kelly Sackett at that time. Plaintiffs also believe after the hearing on these motions, that's the end of the sentence. Plaintiffs also believe after the hearing on these motions. The defense log is not due to be filed until March 5th, 2024, and the hearing for those motions is set for March 1st. The defendants submitted an affidavit by Kelly Sackett that she would respond to any questions asked about her attorney, Matt DePerno. If it was not a privileged communication, the defendant failed to respond to direct questions in the discovery pertaining to his involvement by neither admitting nor denying questions 2, 4, and 5 in the request for admissions. See Exhibit 3, Sackett Affidavit. This will be relevant as to the plaintiff's motion to reconsider the dismissal of KGOP. Exhibit 4, Admission Answers. There were also production requests to provide information that there was, in fact, a coup involving hostile delegates and that the plaintiffs made the motion to set aside Rule 9 regarding questions 13, 14, and 15 in P, their production request. The defendant and or her attorney thought it would be cute and funny to send 5 videos of plaintiff Pritchett Evans that incorporate, for the most part, body augmentation results that have been posted on the internet and have nothing to do with this case. Being that the defense answered this question with the production of the plaintiff's, missing an apostrophe, own videos that have zero relevance to this case, the plaintiffs seek that this court make a ruling to order the defendants to have to use these videos if they are, in fact, going to try and argue that this was part of the coup to set aside Rule 9 by hostile delegates. The plaintiffs also seek that the court allow the plaintiffs to show this material during trial as a response the defendants made in their discovery to our production request, being the defendants. But it would be so appropriate to respond to the plaintiffs' questions. That's actually the correct usage in this case, in this matter. The defendants provided no serious answers to questions submitted by the plaintiffs' discovery requests and should not be rewarded for their unprofessional answers and obvious dodging of questions. Plaintiff intends to show the court the videos at the hearing for this motion. For plaintiffs respectfully request the granting of plaintiff's motion. I don't know what that's about. Do you?
No, okay, so there are 2 matters in Kalamazoo, right? So,
this is the old one. This is Sabrina Pritchett Evans suing Kelly Sackett. This was the old one that was mostly thrown out, except for the defamation issue, which is why they're trying to argue that a coup has occurred, and that's defamation against Kelly Sackett.
Right. To call it a coup is somehow not just defamation per se, which is, I mean, that it's not right. They're going to take testimony. They'll do what they need to do, and they will, and they'll, ultimately this will go away because that's just not what defamation is. Defamation is a much higher standard, but
Right. So let's see what they're talking about here. Where is this body augmentation video? I want to see it now. They neither admitted or denied questions 2, 4, and 5 in the request for admissions. See Exhibit 3. And production request to provide information that there was in fact a coup, and it's made the motion to set aside Rule 9 regarding questions 13, 14, and 15. So 13, 14, 15, 2, 4, and 5. Those are the ones we're looking at here.
Yeah, so when you file for discovery, there's 2 different types of things. There's what's called interrogatories, which is what you're looking at right now. That's an interrogatory. It's a question. And then there's a second section that's called a document production request. It means hand over all the pieces of paper you have that satisfy a certain request.
Mm-hmm.
So I think this will be on the document production request if you have it, because that's videos count as documents. So in connection with the document right there, see where it starts, responses to requests for production of documents.
Yep.
And you may want to, I think they said 13. Yeah, you got to see the video. I don't know if the videos don't work. They must have been emailed to it or they weren't attached. But this is one where I just thrown almost everything out.
So here's the issue. So it says see document production pages 1 to 252. See also 5 videos produced named Exhibit 100 video, Exhibit 101 Make Me Over, Exhibit number 102 Boobs, Tummy, and Butt, Exhibit 103 Inside Track Dan Hartman I want to see these videos. Where can I find these videos?
Is there a restriction on your stream? I don't know. It sounds.
I don't know where to find them.
I don't know. It's a great question. That's a great question.
PDF. Is there a link to them anywhere in here?
No, probably not. They're probably not. That's them complaining about them, and it's
well,
this is one of the ones where it's on its last gasp anyway.
Yeah.
So
to be continued. If we find the videos,
exactly.
we will share them with you guys. We will follow maybe on a weekend stream or something. All right, I think it's going to do it for us for today. Is there anything else I missed, Matt? Or we pretty much
No. We'll reconvene next week, and we'll see what the judge has to say on Tuesday.
All right, sounds good. Till next time, guys. Thanks as always for Audio for Liberty. Peace out.